Hi, I'm Chris Prescott. I'm a partner and immigration attorney with Patel Law Group, and today I'm going to be discussing the H-2B program. As you can see, the title of today's video is Supplement Your Workforce with H-2B Workers. So what is the H-2B program? It's no secret that employers are struggling to find workers. What the H-2B program does, it allows employers to bring over foreign workers on a temporary basis to work in non-agricultural positions. So for example, ground maintenance, landscaping, hospitality, and construction. There's 66,000 visas available per fiscal year. That's split into two halves. There's 33,000 for the start of the fiscal year and then 33,000 for the second half of the fiscal year. In fiscal year 2022, the Biden administration added an additional 55,000 visas. There's two filing windows. The one filing window has just gone. That was July 3rd to the 5th. And then there's a filing window which typically is around January 1st to the 3rd. So the next filing window will be January 1st to the 3rd, 2023. Which employers can use the H-2B program? Basically, any US employer, construction companies, hotels, landscaping companies, etc. The job offer, however, must be temporary. So while technically any employer can file, only certain employers will qualify based on the criteria. How do I recruit, and is there a limit to how many people I can hire? Only candidates from certain countries qualify. So if you go on the USCIS website, there's a list of over 80 countries. It includes Canada, Mexico, Jamaica, Colombia, Turkey. Unfortunately, it does not include India. So how do you find people? Ideally, when you start the process, if you have people in mind, whether they've been referred by friends or colleagues, then great. If you don't have anyone, don't worry. When you start the process with the Department of Labor, you don't have to submit the name of the candidate. And as part of the process, the Department of Labor actually advertises the position on their website. And during the process, you'll probably get resumes from foreign workers. That's people that are abroad and sometimes people that are already in the US on H-2B and are looking to transfer. So there's the potential to find candidates during the process. There's no limit to the number of candidates that you can file for, but the request must be reasonable. So let's say, for example, you have a small hotel and with, I don't know, 4 housekeepers, and you request an additional 2. That would be considered reasonable. If you request 10 housekeepers, probably not. However, if you have multiple locations and you can justify 10 to 20, then it's more likely to be considered reasonable, but bear in mind that you would have to file more paperwork, and that will obviously affect the overall cost. The general eligibility for H-2B, so there's 4 criteria, and the employer has to explain why they need temporary workers based on one of those criteria. So the first one is a one-time occurrence, peak load need, seasonal need, or intermittent need. So for example, the peak load need. We recently filed for a hotel owner who was able to point to 8 to 9 events happening throughout the year that resulted in an increase in occupancy. We were able to successfully argue that this resulted in a peak load need. Seasonal, landscaping is seasonal, hotel on the beach, ski resort, that sort of thing. The intermittent and the one-time occurrence, I think those are the 2 criteria that are probably more difficult to meet, because you have to show that you don't regularly employ workers in that position, whereas with the peak load need and the seasonal need, you're really just saying that you need additional workers. How long can employees stay in the US on a H-2B? Typically 10 months, unless you're filing under the one-time occurrence, in which case it's a year. And then you can potentially extend their stay up to 3 years, which means that somebody coming here on H-2B can stay up to 3 years. After that, they need to leave the US. How much am I required to pay a H-2B worker? So you have to pay the prevailing wage. That will be dependent on the position, the qualifications, and of course the location. So for example, the prevailing wage for a housekeeper in Dallas, Texas is $13.09 per hour. The employer is required to pay all costs associated with obtaining the H-2B, and must reimburse the cost of travel to the US once the individual has completed 50% of their contract. So for example, if somebody's coming over for 10 months, after 5 months, you would have to reimburse them for the cost of their flight to the US. If they complete that contract, so in other words, if they complete the full 10 months, you then have to pay for the reasonable cost of return transportation back home. If the person leaves before the 10 months, you don't have to pay them. Sorry, you don't have to pay the cost of the return flight home. Obviously, you have to pay the prevailing wage as long as you continue to employ them. The process itself takes about 4 to 5 months. So step one is you're dealing with the Department of Labor and you have to request a prevailing wage. It's recommended to file this at least 60 days before the filing window. So if you're looking at the next filing window in January 1st to the 3rd, you would have to backtrack 60 days to make sure you have that prevailing wage in time to file. Step two, you have to submit a temporary employment certification to the Department of Labor, which is essentially a labor certification. And then you have to also submit a job order, and that has to be done during that relevant filing window. So the purpose of obtaining the labor is to demonstrate that there's no available US workers. As I said, 2 filing windows, July 3rd to the 5th. The next filing window, January 1st to the 3rd. So step 3, once you file the application with the Department of Labor, they will assign that application a unique random number, and they'll sort that application into a group, and the groups run from A through F. It could go beyond F depending on how many applications they receive, but in the last filing window, I believe it was A through F. What that means is the analysts at the Department of Labor will go through those groups, starting with Group A, and they will issue either a notice of acceptance or a notice of deficiency. If you get the notice of acceptance, you can move on to the next stage. If you get a notice of deficiency, then you have to respond to that. And sometimes that could just be, something wasn't checked correctly on the form. Once you correct that, you should then get a notice of acceptance. The way that the groups work is if you're in Group A, it means that you potentially can get your labor certified before, let's say, somebody in Group F, and you can then file the application with the USCIS. Bear in mind that there's typically only 33,000 visas available. It's really done on a first come, first served basis. So if you're in Group A and you can get to USCIS faster than somebody in Group F, arguably you've probably got a better chance of getting one of those H-2B visas selected. The nice thing about the H-2B, which is very different from the H-1B, is you can file for multiple workers on the same application. So if you're asking the Department of Labor to certify 10 positions, if that application gets put into Group A, then you potentially get all of those workers, whereas in the H-1B, it's done on an individual basis. So you could file for 10 people and only get 3. So it's really more of an all or nothing approach. Step 4, once you get the notice of acceptance, it will tell you exactly what you need to do in terms of the recruitment. It's a pretty straightforward process. So you have to post an internal notice for 15 consecutive business days. The Department of Labor will place it on their website, seasonaljobs.dol.gov, and that's where you will potentially receive those resumes. So in the last filing we did, the client received over 60 resumes, but none of them were from US workers. So if you didn't have any candidates in mind, you could potentially choose from those workers. So that way, when you file with the USCIS, you've got the people that you want to hire. The employer also has to contact any prior US workers and try and solicit their return to the position. If they get any applications from US workers, they have to review the resumes and interview them. If any of those applicants are qualified, then you would have to hire them. So let's say you submit an application for 10 workers and you get 2 US workers apply and they're qualified, well, the Department of Labor would essentially certify you for the other 8. Department of Labor can require additional recruitment. For example, they may ask you to post it on the website. There used to be a requirement that you would have to do a newspaper advertisement. That requirement is no longer in place, but as part of that additional recruitment, it's possible the Department of Labor could ask you to do that. Step 5, once you've done the recruitment, you prepare a recruitment report, which is sent to the Department of Labor. So you have to include the name and contact for all US workers who applied for the job. You have to confirm how you contacted those US workers and whether the job was offered and whether the applicant accepted or declined. So, as I said, if you get applications or resumes from foreign workers, people that are looking to be hired on H-2B, you don't have to consider those resumes. It's only US workers. Bear in mind, if you're advertising for like a housekeeper position, you may not really have any requirements. So that way, if you get resumes from US workers, you would potentially have to hire them. Now, it doesn't mean they will accept the job. So obviously, if they refuse the job, then you can just continue with the process. Step 6. So if satisfied, the Department of Labor will issue the temporary employment certification. In other words, they will certify the labor, and that will list the number of workers certified. So if you ask for 10 workers, they may certify all 10. Again, if you hire 2 or 3 US workers, they may just certify the other 7 or 8 positions. By getting that certification, the Department of Labor is saying that there are no US workers available to fill that position. Step 7, this is where you file the I-129 with USCIS. You have to include a copy of that labor certification. And you can also file for multiple workers on one application. So if you're looking for 10 construction workers and they're all from the same country, you could file one application with USCIS. However, if you're hiring for multiple positions and those individuals are from multiple countries, you would potentially have to file more than one application. The filing fees, there's a $460 filing fee and a $150 fraud fee. And then if you want to file in premium processing, that's optional for an additional $1,500. If you don't file in premium processing, and premium processing gives you 15 days, or it gives USCIS 15 days to either make a decision, or what they could do is issue a request for further evidence. If you don't file in premium, I believe regular processing is about 5 weeks. Obviously, that can change. Step 8 is the final step in the process. Once USCIS approves the case, each candidate, assuming they're outside of the US, will need to complete a DS-160 and then schedule an appointment at the consulate to get the H-2B visa. Once they get the H-2B visa, they can then enter the US based on the relevant start date. That start date will depend on which filing window you apply in. If you apply in the January filing window, the earliest start date would be April 1st. If you apply in the July filing window, the earliest start date would be October 1st. So let's discuss the next filing window in January. Bear in mind that in order to file that application, you have to have a prevailing wage, which can take 60 days. So if you work back, that means you need to file the prevailing wage by the end of October or the start of November at the very latest. If you don't get that prevailing wage in time, you will miss the filing window, and then you will have to wait till the next filing window, which would be July 2023. Why should I use the H-2B program? You will simply have access to labor which is not currently available in the US. This is exactly why so many companies are filing H-2B visas. You can also file every 6 months because of those 2 filing windows, and then you can potentially file extensions for current H-2B holders. That covers everything for the H-2B program for today. If you have any questions, please email me at cprescott@patellegal.com.